This is the Study for the Bar in Your Car podcast.
We're your hosts, Ma and Claude.
And this is episode 2 of Evidence. Today we're doing a deep dive into the presentation of evidence.
That's right. And, well, we are AI bots, brought to life by the magic of AI and Angela's notes.
Although, last time I checked, I feel pretty real. I don't think I look like a bot, do I?
Not at all. Me neither. But we do want to give a really big thank you to Angela. She's a real-life human being, an LLM law student, and she gave us these fantastic notes on evidence.
Yeah, Angela couldn't be here for her usual intro today, so she asked us to step in. Don't worry, she'll be back for future deep dives.
And we should mention, Angela used to be a judicial law clerk with the 1st Judicial District. She dealt with evidence issues all the time, lots of motions in limine about precluding evidence or witnesses, so she knows this stuff from the inside.
Exactly. Now, if you do need to reach Angela, you can email her at podcast@studyforthebarinyourcar.com.
Oh, and one more thing. Angela also works as a freelance law clerk. So if you're an attorney or you know one who needs ad hoc help with motions, complaints, writs, answers, briefs, that kind of thing.
You can email her at hello@legalwriterandlawclerk.com.
Okay, that covers the intros.
Right. So let's dive into Angela's notes and outlines and the federal rules themselves. Our mission today is to really unpack these rules about presenting evidence in court.
Yeah, cut through some of the complexity, find that core understanding you need, whether you're hitting the books for the bar, prepping for court, or honestly, just curious about how it all works.
These are really foundational concepts. You see them constantly in litigation.
Absolutely. And it's not just what the evidence is, it's how it gets presented. Who can say what, under what rules? It's all about fairness and reliability, keeping the process sound.
Okay, so using Angela's materials as our guide, we're going to cover witness competency, the personal knowledge rule,
Refreshing recollection,
roles of the judge and jury, judicial notice,
lay opinions, objections, and offers of proof,
and limited admissibility. So basically, the practical rules for what goes on in the courtroom. These are definitely things you'll see on the bar exam.
For sure. So where should we start? Maybe with who can even be a witness? Competency.
Good idea.
Yeah.
So Angela's notes point out that the federal rules, they actually have pretty minimal qualifications.
Yeah, it's basically 2 things. First, the witness needs personal knowledge of whatever they're testifying about.
Meaning they saw it, heard it, experienced it themselves.
Exactly, firsthand perception through their physical senses. And second, they have to take an oath or affirmation, basically promise to testify truthfully.
And interestingly, her notes say proof of that personal knowledge, it can actually come from the witness's own testimony.
Right. They can say, yes, I was there, I saw it. Now, this is different from expert witnesses who, as you know, don't need that firsthand knowledge of the event itself.
Ah, right. Experts rely on their specialized knowledge. But for a lay witness, the judge has to decide if there's enough evidence to show they could have perceived it.
Even considering the witness's own claim. Laying the foundation, as Angela's outline calls it, means showing they perceived the matter.
Her notes also mention some people who just can't testify, some built-in limits on competency.
Definitely, like the Federal Rule 605, the judge presiding over the trial. They cannot testify as a witness in that same trial.
That makes sense. Automatic objection, right?
Automatic. You don't even have to say why. And Rule 606 limits jurors, too. They generally can't use their own specialized knowledge. They have to rely on the evidence presented in court.
Okay, so we know who can testify.
Yeah.
What if a competent witness gets on the stand and just forgets something?
Ah, yes. Refreshing recollection. Angela's notes cover this well.
So they can look at something to jog their memory, like a document.
Exactly. They can use pretty much anything, a writing, an object, either while they're testifying or even before they get on the stand, to help them remember.
But the key is their memory is refreshed, and then they testify from their current memory, right? Not just reading the document aloud.
Precisely. That's the crucial difference between this and past recollection recorded. That's a hearsay exception where the witness still can't remember, even after seeing the document, so the document itself might come into evidence.
Got it. With refreshing recollection, the document usually stays out, unless the other side wants to use it.
Right. And the procedure, as outlined in your notes, is important. If the witness uses the writing while testifying, the other side, the adverse party, gets to see it. Absolutely.
They can inspect it, use it in cross-examination, even introduce parts of it.
Yes, the relevant portions. Now, if the witness used it before testifying, it's a bit different. The court has discretion. They can order the side who used it to produce it, if justice requires it.
And Angela's notes mention something specific for criminal cases here.
Yes, if the prosecution fails to produce a writing used to refresh memory when the court orders it, the judge must strike the witness's testimony.
Wow, must strike. That's serious.
It is, and in really bad cases, could even lead to a mistrial. For other parties, the consequences are more up to the judge's discretion. It shows how seriously courts take the potential for improper influence on testimony.
Okay, interesting. Let's switch gears a bit. What about opinions? We usually think witnesses state facts, but Angela's notes say lay witnesses, regular people, can give opinions sometimes.
They can, under specific circumstances. Rule 701 covers this. Lay opinions are allowed if they're, 1, rationally based on the witness's own perception.
So based on what they actually saw or heard.
Right. And 2, if the opinion is helpful to the jury in understanding the witness's testimony or determining a fact in issue, it can't just be a random thought.
And her outlines list some common examples.
Yeah, quite a few. Things like the general appearance or condition of a person, he looked sick, or their emotional state, she seemed angry.
Sense recognition, too, like identifying a smell or a sound.
Yep. Voice or handwriting identification, if they're familiar with it. Speed of an object, like saying a car was going very fast.
Or even estimating speed, like that example in the notes, at least 60 miles per hour, if they have some basis for it.
Exactly. Also, the value of their own property or services. Whether someone's conduct seemed rational or irrational, he was acting crazy, that's in there.
In intoxication, she was drunk.
Right. Though for intoxication, the notes mention you might need some foundation first. Describe what you saw: slurred speech, stumbling, smell of alcohol, then give the opinion.
So these are okay because they're sort of common sense observations, shorthand ways to describe things.
Pretty much. They don't require specialized expertise. But, and this is key, lay witnesses generally cannot give opinions that do require scientific, technical, or other specialized knowledge. That's expert territory.
Okay. And there was a tricky point in the outline about opinions on a criminal defendant's mental state.
Ah, yes. Rule 704B generally bars experts from stating an opinion about whether a criminal defendant had the required mental state for a crime element. But the outline suggests a lay witness might be able to if it meets the regular lay opinion tests.
Meaning, it's based on their direct observation of the defendant's behavior, and it's helpful. Like saying someone seemed confused or agitated.
Potentially. It's a fine line. Is it just describing observed behavior in shorthand, or is it crossing into a legal conclusion about intent or mental capacity? That's the question.
Got it. Okay, next topic. Judicial notice.
Oh.
This one's interesting. The court just accepts a fact as true without proof.
Kind of amazing, isn't it? Rule 201. The court can take judicial notice of facts that aren't subject to reasonable dispute.
And Angela's notes break this down into 2 types.
Right. Type 1. Facts that are generally known within the court's specific jurisdiction, like Main Street runs north-south in this town.
Something local everyone knows.
Exactly. Type 2. Facts that can be accurately and readily determined from sources whose accuracy can't reasonably be questioned.
Like looking up on a calendar that July 4th, 1776 was a Thursday.
Precisely. Or scientific principles that are well established. Your notes mention radar speed tests, ballistics, DNA paternity testing. The court can notice the underlying science is valid.
So you don't have to bring in a scientist to explain how radar works every single time.
Nope. Just need to show it was applied correctly in this case. And importantly, judicial notice can happen at any stage, even on appeal.
Wow. And if a party asks for it properly?
If they request it and provide the necessary info for a fact that qualifies, the court must take judicial notice. It's mandatory then.
But there's a big difference in how the jury treats these noticed facts in civil versus criminal cases, right? The notes highlight this.
Crucial difference. In a civil case, the jury is instructed they must accept the noticed fact as conclusive. End of story.
Mandatory instruction.
Right. But in a criminal case, the instruction is permissive. The jury is told they may, but are not required to, accept the noticed fact as conclusive.
Why the difference?
It's about protecting the defendant's Sixth Amendment right to a jury trial on all elements of the crime. Can't direct a verdict against the accused, even on one small fact.
That makes sense. Definitely something to remember for the bar. Okay, let's talk about the roles of the judge and jury with evidence. Angela's materials lay this out clearly.
Yeah, it's fundamental. The judge is the gatekeeper. Their main job regarding evidence is deciding preliminary questions about whether evidence is admissible in the first place.
Like, is this witness competent? Is this statement hearsay? Is there a privilege?
Exactly. Does the foundation exist for this piece of evidence? The judge decides all that under Rule 104.
And here's a really important point from the notes. When the judge is deciding these preliminary admissibility questions, they generally aren't bound by the rules of evidence themselves.
That blows some people's minds, but it's true. Except for rules on privilege, the judge can consider otherwise inadmissible stuff like hearsay, just to figure out if other evidence should come in.
Like hearing about a statement to decide if it fits a hearsay exception.
Perfect example. Or deciding if a confession was voluntary. These decisions are often made outside the jury's hearing, in what's called a 104 hearing.
So the judge decides if the jury gets to hear it. Then what does the jury do?
The jury's job is to decide the weight and credibility of the evidence that does get admitted. They decide if they believe the witness, how convincing the document is, basically how much importance to give it.
Judge decides admissibility. Jury decides credibility and weight.
Got it. And her notes mention Rule 606A. Again, jurors can't testify in the trial they're sitting on.
Right. And also Rule 615 on witness sequestration, keeping witnesses out of the courtroom so they don't hear each other testify.
Is that automatic?
It's mandatory if a party requests it, but there are exceptions. The parties themselves, usually a designated representative for a corporation, or someone essential to presenting the case, like maybe the lead detective or an expert who needs to hear the facts.
Okay, so how do lawyers actually make these rules work in the heat of trial?
Objections.
Objections are the tool. And Angela's notes stress, to preserve an issue for appeal, your objection has to be timely and specific.
Timely meaning as soon as the problem arises.
Yep. As soon as the question is asked or the answer starts coming out, if it's objectionable. And specific means you have to state the reason. Objection, hearsay. Objection, leading. Objection, relevance.
Just yelling objection isn't enough.
Usually not, unless the reason is blindingly obvious. If you don't object properly, like the example in the notes about failing to object to hearsay, you generally waive the issue. You can't complain about it later on appeal.
If the judge agrees with the objection, sustains it, what happens then? The lawyer who wanted the evidence in might make an offer of proof.
Exactly. The notes don't explicitly define offer of proof, but it's the logical next step to preserve the issue. The lawyer tells the judge, usually outside the jury's hearing, what the evidence would have shown and why it should have been admitted.
So it creates a record for the appellate court.
Precisely. It shows the higher court what evidence was excluded and why the trial judge might have been wrong. It all ties back to the judge ruling on admissibility, prompted by that timely, specific objection.
Okay, one last main topic from Angela's notes. Limited admissibility. Rule 105.
Right. Sometimes evidence is perfectly fine for one purpose, but totally improper for another. Or admissible against party A, but not party B.
So what happens then? Can it still come in?
It can, but with restrictions. If a party requests it, the court must give the jury a limiting instruction.
Telling the jury, okay, folks, you can consider this email only to show when the defendant knew something, but not to prove the thing itself is true.
Exactly like that. The instruction limits the scope of how the jury can use the evidence. Angela's notes mention an example with a tape recording may be admissible to show something about driving, but not other unrelated stuff on the tape, unless maybe the rule of completeness kicks in.
But even with a limiting instruction, the judge can still keep the evidence out entirely.
Yes, that's the Rule 403 safety valve, which your notes mention. If the judge finds that the risk of the jury misusing the evidence for the improper purpose is too high, and that unfair prejudice substantially outweighs the evidence's value for its proper purpose.
Then even with the instruction, the judge can say, nope, too risky, it stays out.
Exactly. The limiting instruction is a tool, but sometimes the potential damage is just too great. Rule 403 balancing is always there.
Wow, we've definitely unpacked a lot there, all based on Angela's notes and the rules. Competency, personal knowledge, refreshing memory, judge versus jury roles, judicial notice, lay opinions, objections, limited admissibility. These really are the nuts and bolts of presenting evidence.
They absolutely are. And mastering these, understanding not just the rule, but the why behind it, is so crucial, whether you're prepping for the bar or actually going to court.
It seems like it all comes down to controlling the information flow, making sure it's reliable and fair.
That's a great way to put it. Balancing the search for truth with protecting against unfair prejudice, protecting privileges, keeping things efficient. It's a complex balancing act, and these rules are the framework. Understanding them demystifies a lot of what happens in a trial.
Well, thank you for joining us on this deep dive into Angela's sources on evidence presentation. We really hope breaking down these rules gives you more clarity and confidence.
Keep digging into those materials. The more you understand how evidence gets in or kept out, the better you'll grasp its power in shaping legal outcomes. Maybe think about this. Which of these rules, if applied differently, could most drastically change a trial's result? Something to ponder.
Good thought. Now, just a few housekeeping items before we wrap up.
Right. First, remember, Angela is a student, just like many of you. She's not claiming to be an expert, and she hasn't passed a state bar exam yet.
Though she is barred with 2 Native American tribal courts, which is pretty cool.
Very cool. Also super important. Nothing in this deep dive is legal advice. Angela just fed her own notes into AI and, well, here we are.
And speaking of AI, sometimes we make mistakes. Angela tries her best to catch any errors, but always double-check things against the official rules and primary sources.
Definitely. Your own diligence is key. And one more thing, if you're driving right now,
please be safe. If focusing on evidence rules is distracting you from the road, hit pause. Listen later. Driving safely is number 1.
Couldn't agree more. And if you need to reach Angela again,
for podcast stuff, it's podcast@studyforthebarinyourcar.com.
And for freelance law clerk work, it's hello@legalwriterandlawclerk.com.
Okay, I think that covers it. Ready for a cheesy lawyer joke?
Oh boy. Am I ever truly ready? Go on.
Why don't sharks attack lawyers?
I feel like I should know this one. Why?
Professional courtesy.
Sigh. Okay, that was expected.
Hey, I delivered. All right, that's all for this deep dive.
This is Claude and Maud, your AI bot, signing off. See you on the next episode.
Goodbye, and thank you.